Today we're going to discuss the topic known as alternate dispute resolution methods, in short ADR. Dispute resolution is basically bringing two or more discordant parties who are having some friction to a clear understanding so that their differences are removed. We're trying to do or settle a dispute between the two entities. You can think of a dispute that you've been involved in or that you have experienced and see how that particular dispute has been resolved. Keep that particular example in your mind as we go on with this particular aspect. Civil disputes occur when a person's rights have been infringed on an individual or an individual has been injured as a result of another's action. Alternative dispute resolution involves settling a civil legal dispute by a method other than a decision before a court. So here we have the different types of alternate dispute resolution. The first one is a mediation, then we have arbitration, conciliation, and we have the combination of mediation and arbitration and conciliation and arbitration. Okay. So when we have an alternate dispute resolution system, we also have something known as negotiation. Now we'll go into each of these in more detail. So negotiation is basically involving two or more parties with some kind of conflicting interest and they work towards an agreement on how they will cooperate. So this is carried out with only the two parties, party A and party B. There is no third person involvement into this. They sort out their issues and then they move on. So we see that in this particular type of negotiation that we're talking about, okay, we see that these are the seven elements: the interests, the options, where both the parties can agree. If they don't agree, then what is the alternative? Then how persuasive is each party? Are both parties willing to discuss and listen, sit down and talk? Relationship, are they able to establish an operational relationship so that once they are finalized on the negotiation at a later stage, there should not be any kind of problem. Okay. Next, we come to the second aspect that is known as mediation. An ounce of mediation is worth a pound of arbitration and a ton of litigation. Right. This is by Joseph Greenbaum. Here, mediation, we can say, is a second step of negotiation where the two parties are there, they are discussing, but there is also a third person that is involved who listens and directs but does not suggest. He listens and directs both of the parties' discussion but does not give any kind of outcome or suggest any kind of outcome to the two parties. So in mediation, the court would choose the mediator, decide a schedule, engage, discuss with the mediator, and then finally endorse a deal. Conciliation involves a third party. So it is again, we are seeing it is producing to the higher step, right? So it involves a third party, but this time the third party can make suggestions. So depending from case to case, we can have. Okay, so here we see the conciliation is similar to mediation, but the third party is playing an active role in putting forward the suggestions of compromise. Okay. Next is the last one that is known as arbitration. Arbitration involves an independent third party who actually makes suggestions and actually imposes a decision. So we see in the previous one that we talked about conciliation is going to suggest. But here in arbitration, we see that the third party can impose a decision on the parties. Okay. So we can say that the arbitration is a quasi-judicial system. Okay. It's a quasi-judicial system and it is a court-imposed arbitration and that's why it is binding. When we come to litigation, it is a legal process for taking dispute through standard court with the aim of engaging in judicial contest to achieve credible statement. Now, in all of these things that we saw, negotiation, mediation, conciliation, and arbitration, both the parties will finally endorse a deal. Okay, so trying to dissolve or resolve the dispute. Hence, once the deal is endorsed by both the parties, there is no opportunity for them to appeal, because it is they are giving their consent and they're saying that they're okay with the decision that both the parties have come about with. Okay. Yeah. Thank you.